case briefs, and so much more. LSData's got what you're looking for.
In the 2010 case of Stolt-Nielsen S.A.V. AnimalFeeds International Corp., the U.S. Supreme Court entered a dispute between two shipping companies and AnimalFeeds International Corp., a global supplier of raw ingredients. The issue at hand pivoted around the crucial idea that arbitration is consensual and can only be instituted if both parties agree to it. The dispute originated from a standard contract known as the Vigelvoy Charter Party used by Animal Feeds. The contract contained an arbitration clause stipulating that any arising disputes would be settled in New York, in accordance with the procedures of the Federal Arbitration Act, FAA. A disagreement arose when Animal Feeds accused the shipping companies of charging super-competitive prices, filing a putative class action against them. The arbitration clause was silent on the issue of class arbitration. It didn't specify whether disputes should be handled on an individual or class-wide basis. The South Carolina Supreme Court held its ground, ruling that arbitrators could impose class-wide arbitration, even when the agreement was silent. This, they determined, was conditional upon the allowance serving overall efficiency and equity, whilst not resulting in any prejudice. The U.S. Supreme Court, which decided to dwell deeper into the issue. The question to answer was whether the FAA allowed an arbitrator to infer an agreement to authorize class action arbitration from the silence in the arbitration agreement. It reaffirmed that arbitration is a matter of consent, siding with the FAA's emphasis on arbitration being consensual, not coercive. He argued that arbitrators could adopt necessary procedures for enforcing agreements, but couldn't impose class action arbitration by assuming silent consent. Instead, consent needed to be explicit. In light of these insights, the case was remanded for subsequent proceedings. This landmark case underscored the crucial notion that agreeing to arbitration does not amount necessarily to agreeing to class action arbitration. Only explicit consent can lead to class arbitration, maintaining the foundation of arbitration as a voluntary, mutually agreed-upon process.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.